Thanks for staying with us here on TVC Breakfast. Now, the House of Representatives has renewed calls for the establishment of a special court dedicated to trying terrorism, banditry, and kidnapping cases across the country. Lawmakers say the scale and speed of these crimes demand a judicial structure that can deliver faster, more coordinated, and more secure trials than the conventional court system currently allows. We examine the practicality, impact, and possible challenges of these proposals. Will the special courts truly fast-track terrorism trials or simply add another bureaucratic layer? Joining us via Zoom for this conversation is a lawyer and public affairs analyst, Fred Nziako. Thank you so much for joining us on TVC Breakfast. Given the sharp increase in coordinated kidnappings, hostage takings, banditry, and so on and so forth, or how others will say what's a view, and the lawmakers are now pushing for us to establish a specialized court to try these people who are found, in this culpable act. Is it an understanding of what the situation really is, or we are deviating from the fact that we already have a court, or is it that the courts are currently lacking in trying these the saboteurs?
In the making of law in any country, certain things are put into perspectives. First, you determine what are the issues and what are the challenges that the law seeks to cure. What are the problems that the law seeks to solve? And secondly, you now look at the issues of logistics, issues of financing, and all other issues relating to such legal statutory establishment. In this case, what the House of Assembly is, House of Reps is seeking to do is to create a special court that will take care of terrorism, kidnapping, and the rest of them. And then the question is, has the existing courts failed in the discharge of such a responsibility that warrants the establishment of a special court? That is one. Two, the issue of creation of court is a constitutional matter because in Nigeria we have 3 layers of court and the
Right. Mr. Fred?
At that level, they have the Supreme Court. And in the event where the High Court is deemed not to be good enough or capable of handling terrorism and such related matters, or not having enough chance to discharge such responsibility, that's when you begin to think of a special court, just like we have the National Industrial Court, which is a court of concurrent jurisdiction with that of the High Court. And even at the High Court level, you have the State High Court and you have the Federal High Court. The question is, the level of court that we had at the level of the High Court that we have, are they not competent enough to handle issues of terrorism? Has any terrorism matter been brought to court and it has not been well handled to warrant the creation of a special court? I think it is a reactionary measure that is born out of trepidation and out of a quick fix approach. And let me summarize by saying that we do not need special court to try terrorism, kidnapping, and other related matters. They fall into the category of crime. We have criminal courts that handle all manner of crimes. The only thing you need to do is that within the High Court establishment, you can have departments that handle matters of that nature. Just like at the High Court level, you have civil courts and you have criminal courts, you have family courts, and you have such related courts within the High Court system. All you need to have is to have court that will deal with such high-level criminality to the extent that the judges that will handle such matters will have a special knowledge in that matter. They will have a special training to handle such matter, and then the courtroom will be prepared such that people who want to witness in the court can be shielded if their identity should not be made bare to the public. These are all the things that we need to do. Things that are more administrative than statutory. We need only administrative measures than statutory measures that is being sought to be put in place by the House of Reps. Don't forget that what they are trying to seek is to create another court just like a national industrial court, and that will bloat up the judiciary bureaucracy, because you begin to have another chief judge in charge of that court, and other courtrooms. You begin to build a special court rooms for that, and all that, court buildings, and just increasing the bureaucracy. I think what we need to be done is to increase the number of judges that will handle matters in court, and then establish special arrangement within the court system. I do not think we need special court for that.
You've made it very clear that you are not a fan or a proponent of the establishment of this special terrorism court, but unfortunately, it's no secret that Nigeria's judicial institutions are often under-resourced and overburdened. Perhaps, that is the sentiment that is pushing this push for the special terrorism court. But my question is this: if at all it is finally established and it is put into play, what strategic measures can be put into place to ensure that it's not a parallel system where there's executive overreach? In other words, how can we make sure that it does not become overburdened like the traditional judicial system?
To reduce the dockets of the courts, to reduce the overburdenedness that the judges are facing, is a very straightforward approach. One, increase the number of judges. There are so many lawyers who are eminently qualified to be appointed judges. And we should stop this approach of appointment of judges based on who knows who. If you employ lawyers who are very knowledgeable, who are diligent enough, who are willing to serve, and then increase the number. That is one. Two, increase the facilities of the courts, finance the judicial process adequately so that the facilities will be increased, and then the court will be able to handle matters timeously without much delay. The Administration of Criminal Justice Act 2015, which has almost become a national law, because so many states have adopted the same law, domesticated the laws at their various states, had made provision for timeous and expeditious adjudication of criminal trials in Nigeria. The challenge that we have is because of the overburdenedness on account of the large number of cases that the judges have to handle, coupled with the poor facilities that they face. If we take care of these two administrative infractions, then we'll begin to have expeditious trial. And don't forget that a criminal can only be tried when he is arrested. The process of attacking terrorism leaves very little room for arrest of terrorists. That is what we have been saying. It leaves very little room, because in the crossfire, it's either the terrorists are killed or they escape. So we should first and foremost fortify our military attack against the terrorists, so that you have very, very limited number of them to be dragged to the court. What the system wants all over the world is that they should be finished, they should be eliminated, and they should not even be allowed to operate in the first instance. Deploy technology, deploy military might, and finish off terrorism and drive away terrorists from Nigerian soil. The terrorism is not burglary or mild stealing or a small crime that you begin to say, oh, drag him to court. Before even the process of dragging a terrorist to court on its own raises a lot of security concerns because of the attack that could attend to such a process. Yes, we know that there will not be extrajudicial killing, but in the course of fight against terrorism, any terrorist that is killed is welcome by the society. So I think that instead of wasting time and resources trying to create an extra court system that will try terrorism, kidnapping, and the rest of them, we should expand the existing facilities and equip the military, give them the support that they need, so that terrorists will be finished in the field and not in the courtroom.
All right, so I also hold the view that a special court for terrorists and bandits and all that is not the way to go. But I'm not a lawyer, so I will need some clarity from you. Let's assume that the federal government okays this proposal and says we are going to establish special courts for that, how long will it take? What are the processes that we have to go through for us to have a court like that? And one of the reasons, in fact, the main reason why everybody is saying let's have a special court for it is because the judicial system in Nigeria is quite slow. So they need expedited court cases for terrorism and all that. So this is two questions for you, sir. What does it take for Nigeria to establish courts like that? And how long do you think we have to do this for us to get the courts as proposed?
It requires amendment of the Constitution. The relevant sections, Section 251 and the rest of them. The 251 talks about the establishment of federal high courts. Then another section talks about the establishment of state high court. These are constitutional issues. What it now means is that we have to amend the Constitution. There's also a section of the Constitution. In fact, the Constitution initially did not recognize the establishment of National Industrial Court, but the act that established it placed it at the same pedestal with the federal and the state high court. Okay. It's a recent amendment of the Constitution that recognized the amendment of the special that recognized the establishment of National Industrial Court. So if we go by way of establishing a similar court, just like we have the federal, state, and National Industrial Court, that means it's a constitutional matter that requires amendment of the Constitution, which of course you know that not only that it will have the concurrent agreement of both chambers of National Assembly, it will also have two-thirds majority concurrence of the State House of Assembly in Nigeria. That means at least 24 state houses of assembly will give their concurrent assent to such establishment before such an amendment becomes law. That is one. Two, it also means that the bureaucracy will be enlarged such that the court will be established. You build the courtroom, you appoint the judges, your heads of court, and the rest of them in the various states. Even if it is said to be a national establishment, just like you have the federal high court, you now begin to have various divisions of such court across the country for issue of geographical jurisdiction, because you cannot arrest somebody in Lagos and go and try the person in Abuja, or arrest somebody in Sokoto and you take the person to Abuja. All those geographical logistical challenges will now require that the court will have to be established at least maybe in the 6 geopolitical zones of Nigeria. These are the challenges attendant to such establishment. But we already have the institution of the federal and the state high court, which can try issues of terrorism, issues of kidnapping, and such vices. And all you need to do, like I earlier said, is to expand the existing facilities, appoint new judges, and equip the court. And that's all. That is the low-hanging fruit. And that is the easiest approach to that, so that there will be timeous expedition of judicial trial as it relates to such crimes. Right. Now, the next issue that you may have to worry about is if we say that the process is slow, what has led to such slow process in our court? There are many factors which I have already identified. Let's attack those factors and ensure that judicial trial in Nigeria is made more expeditious and faster than what it is today. Because when they say that justice delayed is justice denied, we must not allow such unwanted delay of trial in the country.
All the same, Mr. Nzako, they say drastic situations also require drastic measures. If that maxim is actually, quoted correctly by me, because I've been struggling with exactly how it is put. but what we look at issues, when we look, if Nigeria decides to go ahead and establish these special courts, we won't be doing this alone. We'll be copying countries like India that has NIA special courts, which is established in 2008. We'll also be following the anti-terrorism courts of Pakistan, anti-terrorism tribunal in Bangladesh, special divisions within the high courts in Kenya. Uganda also has, even the United States also has military commissions in Guantanamo Bay. France also has its own counter-terrorism courts. But you are of the view that there is no need to do all of this. But don't you think we can take lessons from these, international communities who have special courts to try, terrorists. Even terrorists from other countries are also tried within their own country and sentenced to, prison, even executed in some cases.
We need to understand their own environment and the peculiarity of their situation. When you establish such courts, even within the existing court system, they can be called anti-terrorism court. But to establish it and establish and increase the bureaucracy is what I am against. Because in Nigeria, for example, we have criminal courts, we have civil courts. Judges who are handling family and probate issues, they are designated as family courts. So the same way you can have judges who handle anti-terrorism and kidnapping issues, they can now be so designated. What I am against is to establish a different bureaucracy without solving the problem that is on ground. The problem on ground is that the judges are not enough to handle the cases. The facilities in the courts are not adequate. And if you now go and establish another bureaucracy, the same problem that has bogged down the current court system will also affect this new one.
Sorry, when you say the judges aren't enough, when you say the judges aren't enough, is it that judges are not, allowed to assume that position of being judges or justices, or is it that people are not studying any longer, as to get into that level?
Enough judges are not appointed at the both federal and the state level. How can a judge have up to 100 cases to treat in one day? At the end of the day, there are so many adjournments because we have only 24 hours in a day, and we have about 8 hours to work from morning till afternoon. So, and you have so many. Go and look at the cost list of any court in Nigeria, even at the magistrate court level, and see so many matters to be attended to. And that is why matters are not attended to expeditiously. Yes, another factor is the facilities. Why would judges still be writing in longhand in modern day and age? It's only in a few states like Lagos and a few places like Abuja and the rivers that you still have facilities that will record that will deploy technology in court processes. Many other states, their judges still write in longhand. So these are the challenges and the problems we are talking about. If they have adequate facility and there are more number of judges trying different matters, I tell you that we do not need special court. What we need is enlarged facilities and the increased number of judges that will begin to make sure that issues that go to court are expeditedly attended to, because it is causing this increase in self-help and lack of confidence in our judicial system. When people believe that any matter that goes to court will last till their kingdom come, that does not take place in this country that you mentioned. So it does not lie in just increasing the bureaucracy. It lies in making the bureaucracy efficient and not embodying the bureaucracy. That's what I'm saying.
Absolutely, Mr. Nzeako. I'm going to operate from the mindset that this special terrorism court will be established. That's where my question is from. But unfortunately, Nigeria has a history of prosecutions that are often politically influenced, if we're being honest. And so if this special court is put into place, what guarantees can be put into play to ensure that it's not a tool that is used to silence political opponents, silence activists or journalists under the guise of national security?
Of course, you have taken it from my mouth, and I'm happy you said so. Because if you go and see our Anti-Terrorism Act, very often time than not, the government will just arrest activists and opinion molders and begin to charge them for terrorism and cyber stalking and all manner of accusations just because they criticize the government. So you've said it, and that is exactly what it is. If we have to separate the wheat from the chaff, we must remain on issues of law and not mix up law with politics, which is the challenge that we have in our environment as a country. Then if we don't do so, even this so-called special court will still fall into the same challenge and the same problem. So we must ensure that judicial system is separated from political innuendos and political manipulations. And that is very important, and I agree with you completely.
Do we have right now judges and lawyers that specialize in handling cases of terrorism and kidnappings and so on? Do you think that might, yes, do you think that might be one of the reasons that informed this proposal?
These are crimes. A crime is a crime. We have ingredients of crime. We have patterns of prosecuting crimes. The fact that this one is stealing, the other one is arson, the other one is manslaughter, one is murder, one is terrorism, one is the kidnapping. These are all crimes. Yes, there are categories of crimes, and such categories are known by the sentencing that are attendant to that and the punishment associated with such crimes. But it is the same thing. You don't need to be special to go and learn anti-terrorism law separately. But what you need to do is, if there are developments around the world, that is why judges go on short courses. That's why judges go on refresher courses, so that they will be put they will be brought up to date with the latest developments in their various fields of law. And lawyers themselves, from time to time, they go through refresher training and refresher courses. You don't need to go back to law school to begin to learn how to handle anti-terrorism matters, or a judge, you go back to school to learn how to handle terrorism matters. These are crimes. If there are developments in every crime, it will be made known to the industry and to the players in the profession. I do not think that there's anything very, very different from other crimes that the courts have been handling. If the court can handle issues of murder and the rest of them, then why can't the court handle the issues of terrorism and the rest? So I do not think that anything special needs to be done. What needs to be done is to strengthen the facility, enhance that it works better than what it is today, so that people will have confidence in the court system and approach the courts for resolution of issues, disputes, and the problems that are supposed to be resolved by the court, and not allow the court to be made a laughing stock by the way it is done these days in Nigeria, and allow people to resort to self-help, which on its own is extrajudicial.
Yes.
So, well, that's about it for, it's a convenient place for us to actually leave it. Well, we'll see. It's an ongoing debate, ongoing conversation, within the country. We'll see what the federal government and indeed all Nigerians will stand on. Fred Ezeako is a lawyer, public affairs analyst. Thank you so much for your keenness of insight on this topic. Thank you.
Many thanks. Many thanks.